SRIRAM's IAS, serving the nation since 1985. Ab offline ho ya online, we are the lifeline.
Hello students, welcome to SRIRAM's IAS. Welcome to this concept class. This is concept class number 12. I am Mayank Bharadwaj taking this concept class and welcoming you all to a very important and an interesting topic today. So we are going to take article number 20, article number 20 संविधान का. इसमें क्या है? इसमें तीन important concepts हैं. There are three important concepts given under article number 20. Post de facto law. This is one very important concept. The other one is double jeopardy and the third one is self incrimination. इन तीनों के बारे में आज अपन पढ़ेंगे, समझेंगे. For your upcoming prelims examination, this is going to be very handy for you. So an overview of article 20, if you see, it provides protection in respect of conviction for offenses. जिन लोगों के ट्रायल हो रहे हैं, जिन लोगों को पकड़ा गया है किसी क्रिमिनल एक्टिविटी के अंदर, उन लोगों के ट्रायल चल रहे हैं या फिर वो कन्विक्ट हो चुके हैं, ऐसे लोगों के भी संविधान में कुछ ना कुछ फंडामेंटल राइट्स हैं. एक प्रिंसिपल है लॉ में विच सेज दैट अंटिल प्रूवन गिल्टी द पर्सन मस्ट बी परसीव्ड एज एन इनोसेंट पर्सन. तो किसी भी एक व्यक्ति को मान लीजिए पुलिस ने गिरफ्तार कर लिया और कोर्ट में उसके ऊपर ट्रायल चल रहा है, फाइनल जजमेंट तो नहीं आया है. It is not totally proved in the court of law that the person is guilty, and that is the reason why a person should have some or the other fundamental rights. If the person has been proved guilty and the person is already in jail, even in that matter, there has to be some sort of right which should be extended to the prisoners. Human to hai na? So human right must be extended. Think about a situation if Mr. A is arrested and has been tried in a court of law and has been punished for 10 years of rigorous imprisonment. Okay, but the moment he completes his 10 years and comes out of the jail, he has been punished for the same crime which he committed 10 years back and then sent again to the jail for 10 years. Is this all right? No, this is not all right. This is against the law. This is against the fundamental right of the prisoners, who is also a human being. Okay, so in what provision of the law this can be done? How this can be done? If you do not have the fundamental rights, such as there shall not be an ex post facto law in India, there shall not be double jeopardy, and there shall not be self incrimination, then these kind of activities can be taken place in India. So in a way we can see article number 20 and these three concepts which we are going to study today extends the civil liberties in India against the arbitrary action of the state. The arbitrary action of the state, we have already seen it during the colonial times when the Indian revolutionaries were put into jail for crimes they have not committed, or they were self-incriminated, they were made witnesses against themselves. There was double jeopardy, that simply means that they were punished for the same crime twice and also they were retrospectively punished. All those things in independent India, in sovereign India, in a democratic India would not look good, and the power of the state has to be limited. The arbitrary nature of the state has to be curbed in one or the other way, and article number 20 and these three provisions which we are going to read is a manner in which the limitation on the power of the government is put. I hope you have understood this. Let's move to the next slide and see what it is all about. So there was a debate in the Constituent Assembly on this article number 20. Earlier, Dr. B.R. Ambedkar was suggesting some kind of limitation on article number 20 by putting in clause such as article number 20 and the three important provisions given would be subject to morality, law and order, public order and law and order, and all these reasonable restrictions which are there. But there was opposition in the drafting committee against these subjections, that article number 20 cannot be subjected to anything, because if it is subjected to morality or public order, it would give immense power to the state to act in whichever manner the state wants. फिर तो स्टेट कुछ भी कर सकता है. आपने जैसे ही बोल दिया लॉ एंड ऑर्डर अगर किसी भी समय इन्फ्रिंज हो रहा है तो आप एक इंसान को सेम क्राइम की 2 बार सजा दे सकते हैं. अगर लॉ एंड ऑर्डर किसी भी तरह से इन्फ्रिंज हो रहा है तो आप एक इंसान को उसके खुद के खिलाफ विटनेस बना सकते हैं. ऑल दीज वुड बी डिजास्ट्रस, एंड फॉर दैट रीजन this proposition made by Dr. B.R. Ambedkar was opposed in the drafting committee, and hence he agreed to it that article number 20 must not have any subjection like morality or law and order or public order. And for that reason the pure article which was accepted and written was accepted by the drafting committee and then moved on to the Constituent Assembly for further debates, and it was passed and made a part of the fundamental rights of the Constitution of India. This is all inspired by post-World War II human right frameworks. There were so many human right frameworks which were made. There were many declarations during that time, and many countries, the independent countries, have contributed towards the making of the human right declaration, and they have accepted it, they have signed it, being a signatory to all those things, and they have also implemented the human right framework in their local governance. India was one of them. India anyway was against violent revolutions. If you see our independent struggle, most of it was non-violent struggle led by Mahatma Gandhi. So article number 20 clause number 1, ex post facto law. Ex post facto law. देखिए 2 इंपॉर्टेंट चीजें हैं इसमें. अगर किसी बंदे ने कोई क्राइम किया, मान लीजिए if this person A has committed some crime in the year 2012, okay, and year 2025 is running, the punishment for this crime in the year 2012 was 1 year, but it has been increased to 10 years now. Should this Mr. A be put into the jail again for completing the remaining 9 years? Will that be good? Will that be justified? Will that be according to the fundamental rights? This is called post de facto law, means applying the criminal legislation retrospectively. There is another thing, if you see, there is also another aspect of this particular provision. Let's say, let's take same example. If Mr. A has committed an act in the year 2012 which was not a crime in the year 2012, but in the year 2025 that particular act committed by Mr. A has become a crime. So should he be punished for something he did in 2012? So retrospective means in the back date, increasing the term of punishment or making something a punishable offense which was not a punishable offense in the back date is not allowed. That is what is called post de facto law, which is not allowed, which is prohibited in India under clause 1 of article number 20. पीछे की डेट में जाके किसी को भी सजा नहीं दे सकते हैं. If the law has changed today for any act which was not a crime, then from now on and from here on that particular act will be considered as a criminal offense. But taking example of yesterday or a day before that or a day before that, it will not be considered as a criminal offense because the law has been made today. It cannot be applied retrospectively, it has to be applied prospectively. आगे की तरफ ही लागू होगा, पीछे जाके समय में कोई चीज लागू नहीं होगी. I hope you have understood this. अगर आपने एक पेन चुराया, 1 साल पहले, जिसकी कोई भी सजा नहीं थी, बट आज उसकी सजा 10 साल है, और आपको उस क्राइम के लिए पकड़ लिया जाए बिकॉज आपने एक पेन चुराया था लास्ट ईयर, इज दिस जस्टिफाइड? बिकॉज इट वॉज नॉट अ क्राइम देन। और अगर मान लीजिए ये पेन चुराने की सजा लास्ट ईयर 5 साल थी, बट उसको बढ़ाकर अभी 10 साल कर दिया जाए, what will happen? Will your punishment of 5 years be increased to 10? That is also not justified. So आज अभी इस वक्त जो भी एक्ट्स ऑफेंसेस गिने जा रहे हैं, जो भी एक्ट्स क्रिमिनल ऑफेंसेस हैं, उन्हीं पर सजा होगी. Something which has happened at the back date in the year 2024, 23, in the year 2022, if they are not a criminal activity, if they are not criminal offenses, they cannot be declared as a criminal offense by any law passed by the parliament today in 2025. I hope you have understood the meaning of post de facto law, ex post de facto law. So no retrospective criminal laws are allowed. Substantive laws can't be applied retrospectively. Now understand what is substantive law. Substantive law are the laws which tells about the rights, responsibilities, obligations and liabilities of an individual, such as IPC. Whereas there is another category of law which is called the procedural law, which tells about the procedure such as civil procedure code or criminal procedure code. In that, retrospectively you can apply the laws, okay, but it should be favoring the accused, it shall not be against the accused, okay. So there was a case called Kedarnath versus State of West Bengal. Procedural law, in this Supreme Court has said that procedural laws may apply retrospectively but not substantive laws, because this is changing the procedure. And in any way the civil cases, they can be applied retrospectively, but criminal cases, not in criminal cases. There shall not be any kind of retrospective legislation in criminal cases, although it is allowed in civil cases and in procedural law. So if some changes has to be made from a back date retrospectively in criminal procedure code, Bharatiya BNSS, BNSS, what is the full form? BNSS, Bharatiya Nyaya Suraksha Samhita. These are the new laws which has been made, replacing the age-old law of CRPC. Sorry. So I hope you are getting the concept clearly. Now moving forward, this is clause number 2, very important clause. Double jeopardy simply means a person shall not be punished twice for the same crime. If a person was already in jail, there was a trial and the judgment has came, then the person comes out and goes inside again for the same crime. For the same crime he has committed. This is unjustified. This is against the fundamental right. This is also against the human right. Okay, I hope you have understood this. So for example, a person has been tried by a court of law and has been given a death sentence. But this death sentence has not been executed for more than 20 years. What happens in this position? The person was already in the jail waiting for his death sentence for 20 years. That simply means he is already imprisoned for life. This is one punishment. And then you give him death sentence. This is double punishment. So in many cases, a debate has came up in front of the Supreme Court that whether the death sentence, if given to a person, should be executed immediately or after so many years. Because if it is executed after so many years, the person would be punished for the same crime twice. That is against the fundamental rights. That is against the human rights. I hope you've got it. So that is what is double jeopardy, that the person must not be punished for the same crime twice. If the person has committed two crimes, let's say there are two crimes. He has committed a murder in the month of June. Then he has committed the murder in the month of July. These are two different crimes. Although they can be clubbed and he can be tried, but let's say he has committed a third crime of robbery in the month of August. Then these are three different crimes. But if the person has committed only one crime in the month of July and he is punished for it for, let's say, 15 years, and when he comes out, he is again sent to jail for the same crime for 5 years, 10 years, 15 years, whatever, that is against the fundamental right of the prisoner. So that is also not allowed. This is a provision to extend the civil liberties in India against the arbitrary nature of the state. I hope you are getting it. No person shall be prosecuted and punished more than once for the same crime. Only applies to judicial punishment. So what does this mean? If, let's say, a person was a public officer and he has committed some crime. Now there are two different kind of inquiries going against him. One by the judicial magistrate and another departmental. Another departmental inquiry is going on against him. So this will not be considered under double jeopardy. The department has the right to punish the person for whatever wrong he has done, and at the same time the person has to be tried by the magistrate court, session court also. So these are two different things. They must not be counted under double jeopardy. That, people may come up and say he has already been punished by the session court and then he has been punished by department also, but department inquiry is not counted in double jeopardy. This is very important for you to understand. Now, moving on to the third important concept of self-incrimination. So no person can be held a witness against himself. मान लीजिए किसी व्यक्ति को पुलिस ने पकड़ा बिकॉज ऑफ सम क्राइम और कोर्ट ऑफ लॉ में ले जाके उसी के खिलाफ स्टेटमेंट दिलवा रहे हैं. दैट इज नॉट permissible. It is the police who has to make the inquiry. It is the police or the investigation agency who has to do the inquiry and investigation and find out the links, find out the evidences to prove that the person has committed the crime. Okay, so I hope you get this also. There is a difference here. If you are taking the signature of a person just to match whether the handwriting of a person or signature of a person which helps you in the investigation, or you are taking the blood samples, you are taking DNA, you are taking urine samples, all these things will not be counted under self-incrimination. Self-incrimination only limits to giving statements against himself. A person shall not be called in the Katghara, where the person against whom the allegations are made, he must not be called into that, and he must not be forced to give a statement against himself. He has all the right to say to the court of law that I am not guilty. If the state thinks that I am guilty, then the state can prove it in the court of law. I hope you are getting. No person accused shall be compelled to be a witness against themselves. Applies only to accuseds, okay, not witnesses. This is important. It does not apply to witnesses. It only applies to the accused person. The person against whom the criminal proceeding is going on is called an accused person, not to the witness. So there was an important case, and this case has also linked to right to privacy. If you see, these provisions are somewhere in a broader way are covered under right to privacy also. So some judicial doctrines and judicial pronouncements and other things. If we see MP Jain, he's a great, has great knowledge in the field of law, constitutional law. He writes that part of criminal justice triad. Article number 20 is the part of criminal justice triad. Article number 21 is right to life and personal liberty, whereas article number 22 gives the right to the person. If somebody is arrested, the person must be told the grounds on which the person is arrested. Okay. Also, he must be getting a legal representation to defend himself. If he has taken to a place, the kins of that person must be communicated the place where that person has been taken. All these rights are given in article number 22. Also, this person has to be produced in front of a magistrate within 24 hours. Right to life and personal liberty, this has become a mammoth article. So many interpretations has been done by the Supreme Court. Right to education comes under it, right to clean air comes under it. Parliament has also inserted article 21A for right to education, but clean air, clean water, proper education, health care, right to privacy, everything is covered under article number 21. So it has become a very big, very huge article through these interpretations made by the Supreme Court. And article 20, these three articles combinedly are the triad, which we can say they are the part of criminal justice triad. Through them, criminal justice happens. Keshwananda Bharti case declares article number 20 as the basic structure of the constitution. It cannot, and there is an important issue. See, article number 20 and article number 21 are not suspended during the emergency. This is very important. If an emergency is declared, then the president has the power to declare some of the fundamental rights, not the fundamental rights, but actually the right to move to the court, the remedies, they are suspended by the president under article 359 when the emergency has been imposed on the grounds of war or external aggression. Even during that time, article number 20 and article number 21 are not suspended. Okay, so it's a very important provision which you should remember when you are reading this concept. So article number 20 is a safeguard for personal liberty. It reflects moral legal commitment of Indian state. Moral commitment is there, legal commitment is there, that there shall not be any kind of arbitrary action of the state against the civil liberty of the individuals. If a person has been punished for a crime, then the crime must exist legally. Retrospectively, a person cannot be punished for that crime. Similarly, a person cannot be punished twice for the same crime, and he shall not be or she shall not be made a witness against himself. These are important things to understand, and that is what is the moral and the legal commitment of the Indian state is. Integral to India's constitutional philosophy, of course. It is integral to India's constitutional philosophy. Indian constitutional philosophy is based on so many different moral, ethical values, and this is one of them, the civil liberty, even giving fundamental rights to prisoners or the person who has been alleged to have been committed a crime. The fundamental rights are extended even to them. So, I hope you have understood this concept. Thank you very much for joining me in this concept class. And in next concept class, we are going to come up with next important topic. Till then, bye bye and Jai Hind.